again, by virtue of an outside corporation, in this case insurance company, changing their position midstream, is why we are here today. It does not change the intent of what we as council voted on, and that was to gain control, to become a player in the energy field. For 54 years, this nation has sat on the fence, on the bench, and collected, and has had no say in a resource that we have 100 years worth. But we are here today by virtue of your vote to have a say, to be able to determine the future of coal. And granted that coal is at its lowest level, but technology is such, as we talk today, will improve, has been improving, that coal can become not clean coal, but a more acceptable to the environment. And that example is the amount of dollars that the owners are having to put in place today. Nearly $1 billion put into the units 4 and 5, to clean up by virtue of 1, 2, and 3 going down, which does impact the Navajo Nation revenue. But the owners, along with Navajo Nation, by virtue of their vote, is saying there's a future in the coal industry. And that mining company belongs to us, not anybody else. It belongs to the Navajo Nation. So with that, Mr. Speaker.
One of your other questions was how will the performance bond be paid for? And it will be paid for out of the revenues of the mine. So we will not be coming from Navajo Nation seeking any funding for them. And then one of the things we'll be coming back for, when we were going through our appropriations a few months ago in October, we indicated that that would provide funding for ENTEC for a little bit over a year for ENTEC's internal budget. So at that point, provided that we're showing progress on the acquisition of the mine and have worked effectively with BHP to operate the mine successfully, we would hope that you would continue to fund the ENTEC portion of our cost, but not the mine portion, because that mine portion is covered entirely by the revenues that come from the mine. Thank you, sir. The reclamation bond is a requirement of the Office of Surface Mining, and they require that that the mine owner, in order to obtain their permit, carry a reclamation bond. And so ENTEC, as the prospective owner of the mine, has the obligation of actually having that insurance contract for the reclamation bond with an outside insurance company. The reclamation bond will pay out like any other kind of insurance. So the reclamation bond is essentially to guarantee that the land will be able to be reclaimed in accordance with federal laws. Ultimate reclamation obligation, which initially sits with the mine owner, which is ENTEC. However, by way of our coal supply agreement, we have passed that obligation on to the Four Corners Power Plant. So under our 2016 coal supply agreement, they will be pre-funding the reclamation obligation. So what this bond is essentially being used this insurance contract will cover the rest. That's the purpose of the reclamation bond, performance contract. And this contract is required by the Four Corners Power Plant to ensure that if there is an interruption to the supply of coal, that there is some source of funds that will help to remedy the particular problem.
Two bonds, one reclamation, has to be the mine owner, can't be BHP. That's why BHP's continued presence doesn't make any difference. It's a matter of federal law. And two is the performance bond, which BHP has guaranteed through its parent corporation. You happen to be our parent corporation. There's no particular change there. Any other comments that I would have on some of these other questions, I would prefer to make an executive session.
And you get this memo coming up. I wish they would have shared it with us right off the bat. It just seemed like it was withheld until anticipating that question to be brought forth. This council unanimously supported the development to move forward on Intech. We got another resolution from Intech, and then we started to get opposition. And one of the things that many of us said is, we don't want to hear Intech come up to the council every council session. But here we are again. I thought due diligence was done. I thought there was attorneys there that knew what was going on. And if someone breached their commitment, their intent, their commitment, then there should be some avenue to say, hey, you backed out on your commitment, and go after them. I understand the self-sufficiency, to be self-reliant. And that was one of the reasons why we supported this legislation, so that we could be able to administer our own natural resources and to transition. Again, let me emphasize that in quotes. That's Intech, right? Transition. Or energy, in this case, or energy dependency.
When you do a contract, you usually have a sovereign immunity provision, let's say at line 5. And then normally in another section of the contract, you'll have a choice of law provision, and you may have a provision for dispute resolutions. So we're looking at these as two separate issues. A waiver of sovereign immunity is one issue, and a place where you can enforce an arbitration determination would be another provision in the contract. So back when there was an 88 council, they enacted the Navajo Nation Arbitration Act. And when they did so, at that particular time, they passed the legislation by a 2/3 vote. So the council has already waived sovereign immunity for arbitration in accordance with the Navajo Arbitration Act a few years back. Now the question is, we're adding another forum, a state forum, as a place to enforce the arbitration award in the event that the arbitration panel makes a determination. And what we're adding is, in addition to the Navajo Nation courts, it's a state court. Recently, been one of the cases that the Navajo Nation was involved in, a judgment that was domesticated in state courts. And it becomes valid when it becomes domesticated in another jurisdiction. So whether it's in state courts or whether it's in federal court, it would have the same effect. If you took a judgment from the Navajo Nation, it could be domesticated in any of the 50 states or in the federal courts possibly also. So once you get a judgment, they can take that judgment and go to another jurisdiction and have it recognized by that particular jurisdiction. jurisdiction. So the way we're looking at this is the waiver has been done already in previous legislation. We're just coming to you to also add another forum where an award of an arbitration can be enforced. In your question was, the folks keep coming back for more and more. In the first negotiations, it was with BHP. That was to acquire the mine. As we moved along, we got to the point of having to do a fuel supply agreement with the plant owners. And as a condition of owning the mine, the federal government, OSM, says you have to have a reclamation bond. So we have to have insurance to satisfy the OSM.
Basically, you take a Navajo Nation court order, you take it into a state court, and you have it made into, domesticated into a state court order. And so looking at those scenarios and the specific language of the Arbitration Act, we don't believe that you need a 2/3 majority vote. You are, basically what this is asking is just to agree with enforcement in state courts if necessary. So we believe because of that, that it does not require a 2/3 majority, but a simple majority is sufficient.
The Navajo Nation hereby expressly, unequivocally, and irrevocably waives its sovereign immunity for the purposes of the general indemnified agreement in accordance with the terms of the agreement and the addendum as provided by Navajo Nation Council. Resolution number, and it will be the number will be this. So immediate.
That's Attorney General dated today, which advises that legislation 036713 would only require a simple majority vote.
Oh my God.
And it explains that because the legislation only authorizes an alternative state form and the Mexico state law for enforcement of binding arbitration and auxiliary, I can pronounce that, proceedings otherwise enter into pursuit of Navajo Sovereign Immunity Act. So thereby, no additional waiver of sovereign immunity is required. That's what the memorandum says.
Just very brief comments. This proposed resolution changes one thing, and that is where a determination of an arbitration panel is to be enforced. It actually doesn't change the process of decision-making in the event of a dispute. The decision makers will be as you approved before, which is they pick one arbitrator, we pick one arbitrator, and those two arbitrators pick a third. That remains. So the court that has the ability to enforce or not an arbitral award is really the tail, and we think that it shouldn't be the tail that wags this enterprise. So with that, Mr. Speaker.
Taylor Bates covered the key points as well. I'll just note that just as this insurance is for NTEC, the contract that we're talking about, the two insurance contracts, the reclamation bond and the performance bond, are agreements and contracts between NTEC and the insurance company. I think there may have been some